Okay, ladies and gentlemen, I'd like to call this meeting to order. It's the Standing Committee on Justice and Human Rights, and this is meeting number 75. And we're televised today. And for the first hour, pursuant to Standing Order 81-4, we're dealing with the main estimates under Vote 1, and then a number of organizations that belong under the Justice portfolio in terms. And so if you have questions specifically to an organization that is listed here, we're hoping that they have representation in whether it's the Supreme Court or the Director of Public Prosecutions. If you have questions specific to their estimates, we can know they might be able to let us know so we can have them here on Wednesday for sure. But if there's a question that the minister may or may not be able to answer specific about their estimates. We are joined by the Honourable Peter Gordon MacKay, who is the Minister of Justice and Attorney General of Canada, with a number of officials from the Justice Department. For the first hour, Mr. MacKay, the floor is yours for an opening statement.
Chair, thank you, colleagues. It's a pleasure to be before you, as noted by the Chair, to discuss the main estimates for the Department of Justice. This is my 56th appearance before a standing committee as a government minister. And joining me today are Deputy Minister and Deputy Attorney General William Pentney, as well as Associate Deputy Minister Pierre Legault, and Senior Assistant Deputy Minister of Policy Donald Paragoff, all who have extensive experience as well before committees and certainly within this department. Mr. Chair, colleagues, in my role as Minister of Justice and Attorney General, I'm responsible for ensuring that our justice system remains fair, relevant and accessible to Canadians. It also involves, of course, overseeing a significant budget with an eye to fiscal prudence and respect for taxpayers. Le gouvernement du Canada a pris des mesures.
The Government of Canada has taken measures regarding a good number of priorities in terms of criminal justice. So, to ensure that the justice system continues to increase the safety and security of Canadians through criminal laws, policies, and programs aimed at making our streets and communities safer.
Recently announced that the Protecting Canadians from Online Crime Act has come into force. This law takes effect very soon and deals specifically with law enforcement online. This is a bill for which you and members of this committee are very familiar, and I thank you for your work in that regard. We've seen increased activity with regard to the subject of cyberbullying, which has had a devastating impact on many young people in Canada, affecting their reputations, their self-esteem, and their mental health. And it has directly contributed to the unfortunate decision that a number of young people have taken to end their own lives. Young people like Rehtaeh Parsons, Amanda Todd, Todd Liuk, and countless others. Which is why the government acted to protect young people from malicious online behavior, such as posting intimate images on the internet and the insidious and relentless harassment that often follows. This is coupled with outreach efforts that are ongoing, education, and the involvement of many people and organizations like the Centre for Child Protection in Winnipeg that has directly contributed to the assistance of young people who are feeling cornered and hopeless and in some cases desperate. Things like gethelpnow.ca, cybertip.ca, these are areas in which young people are able to access information about how to remove offending material. The Government of Canada also understands that Canadians expect their justice system to keep them safe, and we are committed to protecting Canadians from individuals who may pose a high risk to public safety. It's an obligation and responsibility we take very seriously. Obviously, the evolving threat of terrorism is one of those most troubling threats, and in response to this risk, we introduced a bill earlier this year, again, a bill you're familiar with, C-51, to strengthen our existing anti-terrorism laws to ensure that they continue to respond appropriately to all forms of terrorism. The bill, as you know, is currently before the Senate, and among other things, such as enabling police to be more proactive in identifying radicalization and act accordingly, this bill will fill a current gap in the criminal code by creating a new criminal code offense, criminalizing the advocacy and promotion of terrorism, including those that would encourage attacks on Canadians. Protecting victims of crime, another area in which we have been very active, as is this committee. We are moving to provide a more effective voice in our justice system as a key priority for our government. Victims of crime deserve to be treated with courtesy, compassion, and respect. And, Mr. Chair, to that end, we introduced the Victims' Bill of Rights, and it has received royal assent last month. This legislation enables the rights of victims of crime at a federal level and establishes statutory rights to information, protection, participation, and in some cases restitution. It also ensures that there is a complaint process to deal with breaches of those rights. I could mention others, again, that this committee has been seized with, including Quantos Law, tougher penalties for child predators, and several other bills, of which, again, I express my appreciation for the diligence of this committee. But, Mr. Chair, the Department of Justice is estimating net budgetary expenditures of $673.9 million in the year 2015-16, which is a net spending increase of $43.3 million from the 2014-15 main estimates. The net increase in spending illustrates the Government of Canada's commitment to maintaining, as mentioned, the integrity and the importance of our justice system as far as accessibility to it through programs and personnel. Mr. Chair, one especially important area of increased spending totaling $1.9 million represents the funding in support of non-legislative measures to address prostitution. In 2014, The Protection of Communities and Exploited Persons Act came into force. This uniquely Canadian model was informed by the results of government consultations, public consultations on the subject of prostitution in the aftermath of the Supreme Court's decision in Bedford. That consultation received more than 31,000 responses from Canadians in addition to the in-person roundtables. This was the largest consultation, I note, ever undertaken by the Department of Justice to date, and it recognized the significant harms in the legislation associated with prostitution. There is, in combination of Department of Justice money and public safety money, $20 million that are being made available through a fund over 5 years for programs aimed specifically at helping those who sell sexual services to exit prostitution. Mr. Chair, this is a compassionate and common-sense program that we are delivering, and we believe it will make a positive difference. The funding that will provide services such as trauma therapy, addiction recovery, employment training, and financial literacy. It could also be used to support transitional housing, emergency safe houses, child care, and drop-in centres. And there, I can tell you, has been a tremendous uptake on this program funding. In addition, there will be funding made available to help law enforcement agencies connect with those who want to leave prostitution and help find both emergency or long-term services such as those I've just mentioned. The new resource demonstrates the government's commitment to meaningfully support those exploited through prostitution, and we are ensuring that the laws address the serious harms as well associated with prostitution and delivering the protection that vulnerable Canadians and communities have come to expect and deserve from this government. Mr. Chair, in February of 2015, the government announced that it had extended its support for the Aboriginal Justice Strategy to include an additional $11.1 million for fiscal year 2016-2017. The Aboriginal Justice Strategy supports community-based justice programs across the country that have delivered results in reducing crime and victimization in Aboriginal communities. There are approximately 275 Aboriginal justice programs. There is outreach to now over 800 Aboriginal communities, touching every province and territory on and off reserve, rural, urban, and northern communities. Lowering recidivism and reducing the overrepresentation of Aboriginal Canadians in our justice system is at the root. The programs are cost-effective, produce short and long-term savings for Canadians by freeing up police, court, and correctional resources to address more serious crime. This is in addition to other programs such as the $25 million that is directly focused on the subject of murdered and missing Aboriginal women. Although there was an effort with respect to the main estimates, an increase of $43.3 million, there's also been decisions taken around the providing of legal services as part of our commitment to better and more effectively manage resources within the department. There was a department review of the legal services provided to all government departments. As you know, we do a great deal of work on behalf of other departments and other agencies in government. And as a result, we've identified immediate measures to reduce legal services demand and costs. There is another wave that is aimed specifically at simplifying and increasing access to legal services. It will be implemented within the coming fiscal year. Over the next year, the Department will also continue to work to meet the needs of the Government of Canada's policy objectives. They include enhancing legislation to hold offenders accountable, supporting initiatives to address such issues as security and terrorism I referenced earlier, working with other departments to address crime prevention, rehabilitation, treatment and enforcement activities that relate to illicit drugs, and continuing our Aboriginal justice issues. I would also add to that list the work that's done with young offenders, and in particular there are various branches of this Youth Justice Initiative that deal with guns and gangs. These initiatives will help the Department of Justice continue to build a system that improves access and meets the diverse needs of Canadians. Enfin, Monsieur le Président, le gouvernement du Canada.
Mr. Chairman, the Government of Canada is committed to maintaining the integrity of our justice system. We have reaffirmed that commitment through the level of funding the justice portfolio has received. The items that the Department of Justice has submitted to be tabled under Main Estimates 2015-16 will help to ensure that Canada is a just and law-abiding society with an accessible, efficient, and fair system of justice.
Justice portfolio delivers results. I'm proud to say that we'll continue, and aided by very able officials, to see that these funds are spent wisely while ensuring that Canadians do have that fair, relevant, and accessible justice system that they expect. I want to again thank you, Mr. Chair, members of this committee, for your diligence and determination in examining, in many cases, very complex bills and the contribution that you are making in that regard. I look forward to taking your questions over this period, and I know that officials here, similarly, along with representatives from the Office of the Director of Public Prosecutions, Administrative Tribunals Support Service, and other officials will be attending, I believe, at the next meeting on May 13th to ask any questions in those particular areas. Thank you, Chair.
Thank you, Minister. Thank you for your opening remarks. Our first question from the Democratic Party is Madame Beaudoin.
Merci, Monsieur le Président. Merci, Monsieur le Ministre.
Thank you, Mr. Chairman. Thank you, Minister, for being here when we needed you at the committee. You've come here regularly indeed, because criminal justice, law and order bills are very popular with your government, so there's been many of them. This is probably your last time here, so I'm going to take advantage of the 5-6 minutes that I've been given to go over a few points. Now, I understand you are very proud of the budgets that are granted to you. I'm looking at the numbers here. We're not even at the 2013-2014 real expenditures here. And when I was looking at your Economic Action Plan 2015, everything obviously was delayed by the government this time around. But now we've been able to see both the budget and the main estimates and to look at both together. And I think I've seen two very small references over 585 page about criminal justice. So sometimes I have the impression that your government is tough on crime on paper, but
Et on se rappelle tous que
and we all remember that justice delayed is justice denied. You have the same comments as those who work in the justice milieu at all levels, whether it be judges, or whether it be crown prosecutors or defense prosecutors. Their work has been intensely complexified by the multiplication of these various laws and rules in the system, but also by the fact that their work has been made more complicated because they are lacking resources. There is a huge deficiency of judges all across the provinces. Ontario is one of them. Quebec is another. The issue of legal aid has not been resolved. There are serious problems on that end as well. So when you're telling us that your role is to ensure that justice...
C'est assurer que le système soit équitable.
And on January morning of 2015, I see that there are 50 cases of drunk driving are rejected by the courts because the prosecution did not happen in a timely manner. There's a problem. We can't just stick our heads in the sand, and you can't simply appear before committees by suggesting that we've resolved all the problems of the world, because we have increasing delays that have become unreasonable until getting to trial. The costs are increasing more and more. We know that your department has spent a fortune in cases that have appeared before the Supreme Court in order to make sure that criminal justice laws were compliant with the Constitution. You were told many times by the Supreme Court that they were not. So there's a lot of serious problems, and you're not talking about those necessarily. And I'd like to get your comments on all that. And I have a more specific question regarding your main estimates. You're talking about $1.9 million for prostitution. I'd like to know if you've received any reports since the bill was adopted and it was put into force, if there's any changes that have been applied. And I'm also very surprised, extremely surprised, to see that there is no additional monies given to the Victims Ombudsman, even though that was one of the most important aspects of your conservative agenda when it came to law and order. and we see nothing at the level of the Ombudsman, I would think, and again, like I'm saying, it seems that you're tough on paper, but you're not tough when it comes to resources, because people are going to be stuck with these services that aren't properly funded. So that's generally the rant that you'll excuse me for, but it's probably my last opportunity to see you before this committee on a budget that's above $300 million. What's given to justice, at least in my view, it should be at the very heart of Canadians' lives, and it just doesn't measure up.
Merci, mes chers collègues. Les nombres.
Thank you, dear colleagues, for all the numbers. I will try to answer them very quickly and as directly as possible.
I would note that you are correct. Our government has made this a major priority, and we work very closely with Madam O'Sullivan, who's appeared before this committee regularly, especially in recent days on the Victims Bill. And what you will note in terms of the budget 2015 is that there was an increase in one of the most important areas of victimization, and that is with respect to child advocacy centres. So there has been an increase specifically outlined in the budget in that regard. Also with regard to security around courts, including the Supreme Court, and with regard to security generally, which is in the area I would describe as prevention. And those are important areas in terms of the impact on criminal justice. In the
budget, I'm correct to say those are the only two paragraphs, the two that you just mentioned, that are in this budget. It doesn't go very far to support, to have more judges, to have more Crown attorneys, prosecutors around the country.
Well, I'm glad you mentioned judges, because as you would know, while not referenced in the budget specifically, there was an increase in budget with respect to the number of judges now in Quebec, with respect to the number of judges in Alberta, and that is, without a doubt, a very important area of expenditure. There have been certain challenges that you're aware of that we'll not get into detail here that delayed the ability to appoint some of those judges. That issue has now been resolved at the Supreme Court, and the judge, in terms of a transfer, has now taken place, and we can move forward. With regard to some of the other areas that you referenced, including impaired driving, I appeared regularly in provincial court as a prosecutor, and sadly, then as now, we are still seeing far too much carnage on the highways, far too many of these charges, which take up an inordinate amount of time in the court. I note with interest some provinces have proceeded with a provincial administrative approach, which has accelerated the ability in those provinces to deal with that volume of cases. And we're looking at that. We're working with our provincial partners to see if there's things that we can do at the federal level as well. With regard to overall expenditures in the area of justice, many areas of criminality are in decline. That is, of course, something that we are tracking very closely at the department. Other areas, and I referenced the child advocacy centres, because that is an area where we're seeing an increase, sadly, in terms of the volume of cases, and more importantly in terms of victimization. And so to that end, you can never lose sight in terms of these budgetary matters of the overall picture, and that is that we're making record transfers to provinces like yours and mine. In the case of Nova Scotia, there's a 31% overall increase in funding transfers that go to areas of the criminal justice system, that go to areas of health, that go to areas of education, all of which intersect around many of these issues. I mentioned cyberbullying. We are seeing a more active approach taken across the country with regard to how the education system is now allowing kids to get more direct information about how these very insidious activities online affect them, and where they can get help. That's also important in our
What about
health.
prostitution? I talked about prostitution. You didn't say a word about it. Did you get some stats?
Pardon me?
Prostitution, you got some stats since it's...
I'm going to
As
have
you
to
know,
interrupt this
we've
lovely
put money
conversation.
specifically into the area of helping prostitutes. I mentioned that in my opening remarks. Exit prostitution. That disproportionately, as you know, is a concern in a province like Quebec. And, of course, that is money for the very first time, I know, coming from any federal government specifically aimed at helping prostitutes exit the practice.
Okay. Thank you very much. Thank you for those questions and answers. Our next questioner from the Conservative Party is Mr. Decker.
Thank you, Mr. Chair. Thank you, Minister, for being here today, and sharing your comments with us. You mentioned in your opening comments, Minister, about the Protecting Canadians from Online Crime Act, which was formerly known as Bill C-13. You mentioned it's come into force, which is good news. And I understand that you have been visiting some schools across Canada, talking to young Canadians about the dangers of cyberbullying and other forms of online predatory actions. And in particular, I note that you're going to be coming to my city, Mississauga, later this month, visiting a school and speaking to students about this very important issue. I wonder, Minister, if you could explain both the importance of the passage of Bill C-13 and discuss some of the experiences that you've had with students in some of your meetings across Canada.
Well, thank you very much for the question, Mr. Deckard. You've been intimately involved in our efforts to bring this legislation forward and the consultations and the outreach, which, in addition to the bill itself, I would describe is of equal importance. The legislation, as you know, specifically hones in on this subject of the non-consensual distribution of intimate images, and that is part of the concern. Obviously, a young person very often feels completely devastated by those images that are sometimes taken in circumstances that are regrettable, that may involve alcohol abuse, it may involve sexual abuse, it may involve circumstances that are out of context, and yet there is that image haunting that young person for potentially the rest of their life. And we've seen the devastating impact that that can have. And so passing the legislation was important. It sends a message, as criminal justice bills tend to do, of deterrence and denunciation. It's also important that young people are aware of those consequences, but perhaps, again, to come back to your question, we need to reach those young people. And the education system, the schools, have been more amenable to having those discussions take place. In fact, we've been contacted and invited to come and have these discussions at schools. And we will very often have members of a local police department present, people like Leanna MacDonald, who has headed up an incredible effort, not only nationally but internationally, to make young people aware of the assistance that is available to them. We've advertised online. You may have seen some of these very pointed and I think quite impactful messages that are available on television and movie theaters, but most importantly in that venue, in that realm of online communication. And you ask some of my reflections on this. Every time I've been to a school, and I've been to a number now, I learn something new. Young people are very dialed into what's happening online. They are talking more openly and quite frankly about how this is happening. They're aware that it's going on around them to other students. And what we are encouraging them to do is to take a Good Samaritan approach and stop it, confront it when it's happening around them, but also reach out to the person who is often the victim and report it, and to know where to go to get help. To know that there is programs and personnel out there who are prepared to work with them to, in some cases, remove the offending material. It's complex, to say the least. Much of this is happening from outside our own country. Our laws do not allow us to go into the IP service provider's jurisdiction in some cases to try to remove that material. But there's work being done in that regard. I was here previously talking about our alliances with other countries where this is a similar phenomenon. So I'm quite heartened by the very focused attempt that many countries, including our own, have taken to try to save young people, and anyone for that matter. It doesn't apply only to youth, but that's where this impact is perhaps being felt most acutely.
For that, it certainly appears to me that the debate, the national debate that was sparked by the Protecting Canadians from Online Crime Act really has become well discussed across Canada. You hear teachers, parents, students talking about it. I hear a lot of discussion about it in online discussion groups, on radio and television programs that discuss this issue. And I know that you mentioned that the government's done some advertising on this. It's really very important that all young people know about the dangers that are out there online and how to protect themselves. So that sounds like it's going very well, and I commend you for that. I want to also ask you about the Victims' Bill of Rights. You mentioned that as well in your opening remarks, and that has recently received royal assent. That's quite revolutionary legislation, as you know, and I know that you put a lot of effort into bringing that bill forward and having it passed in Parliament. I wonder if you could tell us a bit about the Victims' Bill of Rights, and in particular how the Victims Fund at the Department of Justice correlates with the Victims' Bill of Rights and enhancing services to victims.
Well, again, I thank you, Mr. Deckard. This is an issue that I think is personal for most, and you, like many members of this committee, have had an opportunity to hear from victims and their families. This legislation is groundbreaking in that it entrenches in federal law for the first time, as you know well, those rights to which victims will now be able to really point to, the way that those who are accused of serious crime similarly have legislation that they can depend on. Now this is encapsulated in that Victims' Bill. Madame Boivin mentioned the Victims' Ombudsman's Office. That was also a creation of our government. We have been funding her office's ability to assist and in the future, of course, to help see that these rights are being respected and given due course and consideration. There is funding as well that we have put in place that is attached to victims, that is attached to the programs that victims can avail themselves of. And I'll refer to those specifically, but I think the transformation, if you will, and I don't think that's too grandiose a word, will be felt by victims in the common best practices that will emerge when that Victims' Bill is fully adopted and embraced, as I expect it will be. Victims will have a much greater sense of import and involvement in their own case. They will have a greater sense of respect from all of the actors within our criminal justice system. But the Victims Fund itself does put in place additional resources. It will allow us to give meaning to those victims' rights. It will be part of the initial commitment that we made when we came to government in 2006. This is a victims fund that is very much aimed at helping with counseling, with compassionate support that is often required by victims in the aftermath, in particular of violent crime. It is there for youth, for their families. It also involves, of course, working with the provinces on a strategy to see that victims are given the type of support, not just financial support, but real support that helps them move past the crime and move on with their lives. The lingering effects of crime, we know, are very real. We know that it has an enormous impact in terms of lost productivity and wages. And, you know, the overall programs are aimed to diminish that, but it's estimated that it's about $100 billion in overall impact in our country, borne substantially 85 or 90% by victims themselves. So these programs are beginning to have an effect. It won't turn around overnight, but victims will feel far more valued, legitimized, and a part of the justice system. One of the more shocking revelations I heard, Mr. Chair, in the consultations was victims saying, I wouldn't go through it again. I wouldn't report it. I felt re-victimized. We're turning that tide.
Good, thank you.
Those questions and answers. Our next question from the Liberal Party is Mr. Casey.
Thank you, Mr. Chair. Mr. Minister, I want to ask you about the Carter case, where the Supreme Court of Canada unanimously ruled unconstitutional the laws that deal with physician-assisted death. And I'm sure you'll recall, Minister, that shortly after the case was handed down by the court and a 12-month delay in the implementation of its effect was decided upon. Shortly after that, there was a motion presented by the Liberal Party, an Opposition Day motion, which set forth a framework for the development of a response to the Supreme Court's decision. And you will undoubtedly recall, Minister, that the government voted down that motion and that framework, and the government suggested at the time that they would adopt their own framework, that framework wouldn't involve a parliamentary committee at the planning stages, that it wouldn't involve opposition members of parliament, it wouldn't be a bipartisan process, and that it may or may not involve going back to the Supreme Court to ask them for an extension of time. So my question for you, Minister, is can you provide us with any more information on what process the government has decided to adopt? Where are you in the process, and what resources have been allocated to it?
Thank you very much, Mr. Chair. This is an issue that Minister Casey has raised that is certainly one that we are well seized of. The Supreme Court's decision in Carter is one that has far-reaching impact, to say the least. Many groups have already expressed themselves in terms of their concerns. Some would call it a divisive issue. It is very much a human issue that impacts disabilities groups, faith-based groups. Certainly the legal and medical community will be involved in the consultation. So the consultation, while not formally announced, has begun. And we have already, without soliciting, received input on the subject matter. When the Supreme Court struck down the sections of the Criminal Code on the prohibition of physician-assisted dying as constitutionally invalid, this, in effect, removed those sections from the Criminal Code. But there was a suspension of 12 months as to the effect. And as we've done previously, we will consult broadly. I mentioned some of the areas and some of the groups who, by necessity, will be part of that conversation. This is not to suggest that there won't be further discussion, parliamentary discussion, and there will be inevitably when a response is tabled. But this will be a national discussion that will involve many in the country. We've done it, I referenced in my opening remarks, we've done this on the response to the Bedford decision. So we have a working model, in effect, that will allow for broad consultation. And we'll do so in a way that's respectful, that's inclusive, that will, in some degree, try to emphasize the inclusiveness and not necessarily the partisan aspects of this. So there will be an extra parliamentary consultation that we intend to undertake, and I'll have more to say about that in the very near future.
So there has been no call for formal consultations, and the process that you will have something more to say about in the near future may or may not look like the same process that was followed with the prostitution case. Is that what I'm to take from what you just said, Minister?
Well, you can take from it what you wish. I said what I said. We're going to involve a very broad, sweeping consultation within the country that will be extra parliamentary. We intend very much to ensure that we do this in a respectful way that does not presuppose an outcome. The decision taken by the Supreme Court, while they've given us a year to respond, members here will know that some 12 years plus after Rodriguez, the Supreme Court took a very different view of what the Supreme Court had previously said. So 12 years to come to a different conclusion, giving the Government of Canada 12 months to respond. So we'll take the necessary time to do this properly. And in the middle of all of this, as we know, there's this other consultation that's taking place called an election.
Staying on the topic of court cases, Mr. Minister, the government has spent $425,000 with respect to litigation around safe injection sites in the Vancouver downtown east side, $350,000 with respect to the Nadal reference, $1 million with respect to the healthcare refugees case. There has been some coverage on it, certainly through the media. My question for you, Mr. Minister, given that all of these cases and all of these expenditures relate to the government's attempted defense of violation of charter rights, is this a good use of federal money?
Well, I disagree with the premise that it is defense of charter violations. For starters, we've actually lowered, in some cases, the number of litigation, ongoing litigation, and cases that are making their ways through the court. We're looking at ways, obviously, in many instances, to settle cases rather than have them drag on. The reality is the vast majority of cases in which the Government of Canada and directly our department finds itself are not initiated by the Government of Canada. And we still have, having said that, a very laudable success rate in terms of defending positions that we take on principle, that we take because we believe it's in Canadians' interest and in taxpayers' interest.
A case that may not have been initiated by the Government of Canada, but one that's being prolonged by virtue of the Government of Canada's appeal, is the Ishak case involving the niqab at the citizenship ceremony. Can you give us some sense, Mr. Minister, for how much that case has cost the taxpayer to date, and whether you have an envelope set aside for the future proceedings in that case?
Well, obviously not. This is a case that's before the courts, and so for that reason, as Attorney General, Justice Minister, I'm not going to comment on cases that are still before the court. I can say that these are cases like others that make their way through the courts, that are a direct response to an issue that is, in our view, of importance to Canadians. It deals with fundamental values and rights that do sometimes come into conflict. And like previous governments, we've taken what I believe is the position that we will advance, and we'll do so through the courts in a transparent way.
Thank you, Mr. Chair. Mr. Minister, in the Planning and Priorities report from the Department, at page 38, there's an indicator that the Department's going to be able to save $1.7 million by the sunsetting of the Missing and Murdered Aboriginal Women's Initiative. I know you referenced this topic in your opening remarks, but is that a good place for the government to be saving money?
We're actually increasing money in this regard. It's a situation where there was previously determined sunsetting, but in terms of the actual money that will be devoted to this important issue, there will be an increase through our department, the Department of Justice, but that's in addition to the funding that is coming from the status of women, that is coming from public safety. So year over year, dollar over dollar, our government has significantly, I mean substantially, increased both resources, programming, personnel, availability for more support on and off reserve. That's without getting into the area of the DNA data banking, the unidentified remains, other subject matters in which impact directly on what we all want to see, and that is justice for murdered and missing Aboriginal women and their families. And much of that is, of course, the arrest and prosecution and holding to account of those responsible.
Okay, thank you very much. Thanks for those questions and answers. Our next questioner from the Conservative Party is Mr. Wilkes.
And, Minister, in your opening remarks, you spoke about, excuse me, the Aboriginal Justice Strategy, and you talked about your passion toward related issues amongst Aboriginal communities. You mentioned 275 Aboriginal programs and through 800 Aboriginal communities. I wonder if you could just discuss the importance of these types of initiatives within the Aboriginal communities and talk about the Aboriginal Justice Strategy some more.
Well, the strategy, in my view, is having the desired effect. It is ongoing. It is a very, very challenging and troubling scenario that we're all aware of, given the disproportionate number of Aboriginal people, young Aboriginal people in particular, who find their way into the system and are incarcerated. The numbers are staggering. So the program and the outreach and the ability to provide alternative programming, programming that is arrived at in many cases in consultation with First Nations, because the sheer size of the country, the diversity of different bands in different parts of the country necessitates that we don't take the one-size-fits-all approach. And some communities are obviously focused more on addressing issues of addiction, for example, issues that relate to gang violence or violence that is very much of a domestic nature or focus. And so the programs, as I mentioned, are very diverse and tailored in many cases to those communities, tailored in a way that we think involves their input first and foremost, but allows us to respond in a preemptive and preventative way as opposed to simply reacting. And that's borne out, again, through great effort on behalf of people not only in our department, but those who are working in Indian and Northern Affairs, those who are working to help with employment issues, for example. I take an example from a community in my own constituency, the Pictou First Nations, where a lot of the effort now is aimed at engaging young people coming out of high school and getting them into the workforce, and doing so in a way that respects their heritage and their culture, but allows them to be gainfully employed and to pursue areas of employment that are of interest to them, helping them with their own businesses. So it's an approach that I think is having a very important effect in reducing that overrepresentation, in lowering recidivism rates, in embracing community responses to criminality. And the Aboriginal Justice Strategy was renewed for that very reason. It is renewed in a way that is designed to get to young people before they find themselves involved in the criminal justice system. You, as a police officer, know that early engagement, and also building trust. Aboriginal policing is an important part of that strategy, and having members of the RCMP and local police forces also creating employment opportunities there. That adds legitimacy. It adds, in my view, a greater sense of trust when the response to justice issues is being handled primarily by First Nations people themselves. And so their delivery of these programs that we're funding is also, I think, one of the keys to success. And you know, I think that the programs themselves have also proven to be cost-effective, and they produce the type of results that have a lasting impact on communities and on everyone, frankly.
Thank you very much for that. You're also involved with many initiatives to keep our streets safe and keeping the crime rates down. Often this means supporting various preventative initiatives. Recently, you launched a call for nominations for the 2015 Minister of Justice National Youth Justice Police Awards. As I understand, this program recognizes innovative approaches taken by police officers and using provisions under the Youth Criminal Justice Act to deal with youth in conflict with the law. I wonder if you can elaborate on this program and talk about how it fits into our government's approach to tackling crime and keeping our communities safe.
Well, these, again, I think are programs that you yourself, having been so closely associated with policing for much of your life, would celebrate. These awards are aimed at recognizing police officers and youth who engage in some of these programs. It's done very much in collaboration with organizations across the country like the Canadian Association of Chiefs of Police and the Canadian Police Association itself. They work closely with us. And it's about promoting some of those underpinnings and the values of the justice system, fairness, inclusiveness, citizen engagement, everything that we would want to promote and embrace a holistic approach to justice, but to policing, which is very much at the sharp end. It's that enforcement that is sometimes most challenging. So the award is now presented every year, usually in the fall, August or September. It's done, as I mentioned, in close association with police themselves, and it helps recognize those who are doing the heavy lifting in our justice system. Police groups, frontline officers, community groups, other justice participants, and it's open to the public to nominate and to engage and to recognize people deservingly who are making a real difference in their communities. So thank you for the opportunity to promote this, and I hope we will see some great nominations this year.
Okay, thank you for those questions and those answers. Our next question from the New Democratic Party is Madame Play.
Merci beaucoup, Monsieur le Président.
Thank you, Mr. Chair. Thank you, Minister. My first question deals with C-23 that was adopted and, in fact, transfers the Federal Elections Commissioner Office, the one that's that deals with investigations and with managing federal elections. So the responsibility of that office has been transferred to the Public Prosecutions office. However, in the 2015-2016 main estimates, from what I gathered, does not foresee any increase or any additional monies for the management of this new department, that being the Federal Elections Commissioner. First of all, my first question is, will there be a budget set aside for the Public Prosecution Services management of all those things? Because I don't know what the budget was before then. Will it be dramatically reduced compared to before, and what is the amount that you have in mind?
The specific budget allotment I do not have. The Director of Public Prosecutions, the deputy, will be appearing before you, I understand, later this week, and could provide you with that specific amount. I'm not going to pretend that I have that figure with me. The responsibilities, though, you're correct, are coming over to us from a new department. So I suppose the costs associated with that move would be absorbed essentially by our department. The staffing and any specific responsibilities will be assumed by the Department of Justice internally. It isn't to date a new allotment or a new cost associated. And for that same reason, there wouldn't be a great deal of casework that would have emerged thus far. But the officials specifically responsible for that new office will be here and can answer that question. And I will undertake to get a more specific answer myself and provide to the department, to provide to the committee.
Merci beaucoup, Monsieur le Ministre.
Thank you, Minister. Now, my second question has to do with the Victims' Rights Fund. And this Victims' Aid Fund, we talked about it a lot when we studied the bill that was associated to victims' rights. And one of the particulars of the Victims' Rights Charter was that there was going to be some compensatory amounts. Considering that the 2015-2016 main estimates does not foresee a marked increase for the Ombudsman for victims' rights, will the contributions coming from the Victims' Aid Funds increase in consequence?
Funds in the 2015-2016 budget year. So additional resources in the amount of $1.79 million will be received to address what we think are significant harms that flow specifically from prostitution. In the overall picture, when it comes to increased funding, there is a victims fund that will see dollars set aside and accessible for groups and even individuals who are supporting the work in support of victims across the country. There's an application process that is to be followed. The overall budget as far as the victims strategy has been ongoing since 2006. In fact, there was some $158 million provided over the past almost 10 years that was accessible through that fund. The Victims Fund is part of the broader strategy of grants and contributions that are made to provinces, territories, non-governmental organizations, and they deliver programs that are designed specifically to meet the needs of victims groups. So, in short, yes, there is more money available. There is money that is now specifically earmarked. I spoke earlier of the funds that are available for prostitution-related exit strategies. And I know for certain that there have been numerous applications taken from Quebec. I've met with some of those groups in Montreal and in Quebec City. Those funds will start to flow as a consequence of decisions made on a criteria, and they'll start to flow in this budget year. And there's also money, I should note, I believe I enunciated earlier that there is money in that particular pool from public safety, in addition to those coming from the budget of the Department of Justice.
Minute and a half now.
Ici, il y a une réduction de
there is a $1.6 million decrease here that it comes from the sunsetting of a particular provision that seeks to support victims and to prevent violence in Aboriginal communities and to support the national investigation on disappeared persons. Could we have any details on when that financing will come to an end? And why is the Department of Justice not renewing that amount?
Example of a program coming to a conclusion, and there will be additional funds. So the overall pool of funds will actually be larger than it was in previous fiscal years. It's an issue that has to do with a sunsetting program that was earmarked for 5 years, and that was specifically aimed at addressing many different diverse issues around murdered and missing. There was a strategy involved in this, taking immediate steps to improve the response of law enforcement. Some of these planned actions, such as delivering a new National Centre for Missing Persons, Unidentified Remains, the public website, those actions have been completed and funding has been placed.
Quel va être le montant alloué pour...
Will be the amount allotted?
The new action plan that was announced by the Department of Justice, our department will be putting $2 million through the supplementary estimates. So that's the increase I'm referring to. And so that is in addition to the overall program funding. There is also the commitment that has been made of a larger pool of funding that comes from outside the Department of Justice, and that's administered by the Department of Labor and the Department of by Kelly Leach's department, Minister Leach.
Okay.
Thank you for those questions and answers.
So $2 million from Justice.
Our last questioner is our visitor today to the committee, Mr. Menegakis. The floor is yours.
Thank you, Mr. Chair, and thank you, Minister, for your testimony before the committee today. Minister, as we all know, our government has placed considerable focus on bringing forth legislation that will continue to keep Canadians safe in their streets and in the communities in which they live. And you and your department are tasked with delivering a wide range of justice programs, and while at the same time ensuring that we spend within our means. A lot has been said with this latest budget about the importance of balancing the books. Perhaps I can ask you to elaborate on the balance that must be struck, Minister, between delivering an effective and robust justice agenda while being fiscally prudent with taxpayers' money?
I think that is an important consideration, and I thank you, Mr. Menegakis, for stating the obvious. I think it's expected of all departments, quite frankly, that they deliver the services, the programs, the results that are expected, and justice is no exception. But they do so with a mind to ensuring responsibility, accountability of that program spending. Part of that is transparency, as we're exhibiting here. Part of it is also doing, from time to time, examinations of what actual efficiencies can be delivered when it comes to those programs. And it's no small consideration to keep in mind taxpayers' money that is being used to deliver these programs and to deliver the results that we're talking about here. And that there is an expectation, I think, on the part of Canadians that we do balance the budget, that we do get back to a place that is important for Canadians. There's an expectation that we'll be able to achieve savings and find savings through innovation where possible. And it was a very strong commitment that we made. Coming out of a recession now, it's clear that we are one of the few countries, frankly, on the planet that have been able to do this. And, lower taxes, keep the budget balanced in spite of some of the unexpected things that have happened in a very turbulent time around falling oil prices. So not to get too far afield, to answer your question, we're very much mindful of that fact at the Department of Justice, as all ministers will tell you, We've been asked to be very prudent in our requests this year, as previous years, when we go to the Department of Finance and say these are the programs that we're delivering. But we've set certain priorities where we've increased spending. Child advocacy centres was one. Ensuring that we have safety and security around justice facilities was another important area that we sought increases. We have, in fact, to come back to a question from Madame Boivin with respect to legal aid. This is an ongoing concern, and we've kept funding stable where other areas of justice we've had to reduce. We have managed to do that. We've kept the funding stable, which, when calculated over time, does result in a net increase. And when we, of course, transfer significant dollars to provinces for the delivery of many of the justice programs and services, that also I would describe as a direct contribution that the federal government is making to the delivery and the accessibility of justice nationwide.
Yeah, well, Minister, last summer you articulated the government's position, the response to the Bedford decision, both to this committee in Parliament and throughout Canada. And the result of those efforts and the passage of Bill C-36 was a built-in Canada model, which was widely applauded by law enforcement agencies across the country, I might add, by the York Regional Police Service in the region that I live in. With this bill, our government demonstrated our support for the women and compassion for those who are trying to get out of prostitution and stop this circle of violence in their lives. Minister, the passage of Bill C-36 was coupled with a funding commitment to help those who are trying to leave the practice. In these estimates, there's an increase of $1.9 million in support of non-legislative measures to address prostitution. Can you talk a little bit about this funding commitment, please?
Well, thank you, Mr. Manigagis. And I would also be quick to point out that we've actually seen, through the good work of many of the police agencies, the investigators, those on the front line, who have now been able to, as a result of some of this legislation, make some arrests of perpetrators, of those who prey on vulnerable people, and those, quite frankly, who were the target of these changes. Perpetrators, pimps, the Johns, those who are purchasing was where much of this focus is and should be. We also announced, you're right, a complementary fund of $20 million over the next 5 years to help with the compassionate work of helping those who are vulnerable to leave and to exit prostitution, which is an inherently dangerous way to make a living, if I can put it that way. And we've directed these funds to deliver some of the frontline services that are happening now. Make no mistake about it, there is a lot of incredibly important work that's being done. This will buttress those efforts. It may allow for some new programs to emerge that will be available to those who wish to exit. And that overall approach, targeting programs to help those who are in danger and those who are most in need to leave and to find employment, to go through retraining. Sometimes it's as simple as having a place to live, accessing childcare, being able to find a safe place to regroup and to emerge with a better way of life. And that's part and parcel of the bill itself, that additional funding. And it comes, to return to some of the other questions, it comes as a result of a number of overlapping areas that we are trying to focus on the preventative side, whether it's addictions issues, whether it's people who were victimized themselves at a very young age, who are impoverished, who lack the opportunity and the ability in some cases to walk away from that life. Human trafficking is of course very much associated with this issue, and we've had targeted efforts in that regard as well with certain legislation. People like Joy Smith have been leaders in the country, and the online aspect of exploitation very much impacts in prostitution, as does the advertising. So it does require that very holistic, far-reaching approach. The programming for the exit strategy is a piece of that, and as I mentioned, we're starting to roll out now those specific funds because they've been, and I say this with some regret, they've been oversubscribed. I wish I could report to you that there wasn't the need. There is massive need in this regard, and we'll have to look in the future at that targeted amount and also be able to report to your earlier question as to how efficacious we've been in delivering and getting results.
Thank you, Minister, for those answers. Thank you for those questions. Thank you, Committee. That is the time we have with the Minister on mains. Just so you know, we will be dealing with this item again on Wednesday for the first hour with our friends, the officials are here. And just a little heads up for the officials, I'll be doing a little bit of a comparative of the plans and priorities from last year to this year. So I'm looking forward to our discussion. Anyways, with that, we'll suspend as we then will go to discuss Bill C-590. We'll suspend for 2 minutes. Okay, we're going to call this meeting back to order, and we are in our next hour, and we are dealing pursuant to order of reference of Wednesday, October 8th, 2014. We're dealing with Bill C-590, an act to amend the criminal code, the blood alcohol content, and Mr. Pruden is joining us from the Department of Justice. If we have any questions at all, this bill is a private member's bill. It has one clause, I believe. Yes, it does. So, to get started, I will call on this clause. I know, Mr. Director, you'd like to speak to it, and the floor is yours.
Thank you, Mr. Chair. I'd like to propose an amendment to Clause 1, Sub 1 of the bill. I hope the committee members have it before them. It was original. Okay, you're handing it out now? Okay.
Yeah, we're handing out right now.
Government
so it's
Amendment
slightly
A.
different than what came in the mail.
Right.
Slightly different.
Yeah. So, yeah, previously there were two clauses. There was a clause A and a clause B. I'm not moving clause B. So I can read it for the committee. Yeah, it says replace lines 13 to 21 on page 1 with the following: of blood, sub A, is guilty of an indictable offense and is liable to imprisonment for a term not exceeding 10 years, and subclause I, in the case of a first offense, to a fine of not less than $2,000 and to imprisonment for not less than 60 days, and subclause 2, in the case of a second or subsequent offense, to imprisonment for not less than 240 days, or B, is guilty of an offense punishable on summary conviction and is liable BI in the case of a first offense to a fine of not less than $2,000, and little 2I in the case of a second or subsequent offense to imprisonment for not less than 30 days. So the rationale is that while we all support higher penalties for those who drive with a high blood alcohol concentration and for those who drive while impaired and cause bodily harm or death, there are concerns regarding the specific proposals for change in Bill C-590. So accordingly, we're proposing this amendment. Clause 1 sub 1 of the bill proposes an indictable offense for having a blood alcohol concentration exceeding 160 with a mandatory minimum penalty of $2,000 plus 60 days imprisonment and 240 days on the second offense. The concern is that these very significant penalties, particularly for a first offender, could lead to many cases where the driver simply refuses to provide a sample because the penalty for the refusal of offense has a mandatory minimum penalty of only $1,000. This was raised by a number of members of the committee during the examination with witnesses last week. Part A of the motion, therefore, proposes that the offense of driving with a blood alcohol concentration of more than 160 would be a hybrid offense. So on indictment, the penalties would remain as proposed in the bill, and on summary conviction, the mandatory minimum fine for a first offense would be $2,000, which is double the minimum fine for impaired driving, and for a second or subsequent offense, the minimum penalty would be 30 days in prison. Making these changes, we believe that in most cases where the driver has a blood alcohol concentration of over 160 but there is no injury or death, the $2,000 fine combined with the mandatory prohibition on driving for 1 year would be a sufficient deterrent. The very severe penalties on indictment should, at the discretion of the prosecution, be reserved for the most serious cases, for example, where the blood alcohol concentration is well above 160 or where the driver caused significant property damage. So for those reasons, Mr. Chair, we're proposing and we'll support this amendment.
Okay, thank you very much. So there's an amendment on the floor, and Madame Bourgain.
So just to be clear, the one we had received, we can rip. It's no longer good. Excellent. So basically, you're adding a ouais, puis une offense, une infraction hybride avec
A hybrid offense with a summary conviction. That's what we're to take away from this. Okay, well, I've got a question for our justice specialists here. Last week,
un petit peu.
The translation is also good.
OK. La semaine dernière, on a soulevé un point.
Last week, we raised a particularly important point with the sponsor of the bill. There might be certain backroom dealings that come with this bill, which would mean that the refusal of providing a sample for a blood test analysis would mean that somebody would get a lesser sentence than a summary conviction. So there might be the possibility here of trying to avoid the impact of Bill C-590. What do you have to say about that from the department's point of view? And also, isn't there a certain type of injustice? People are going to talk to one another. There will be word of mouth, and it will just render Bill C-590 completely toothless in that regard, because people will know, especially when it comes to recidivism and people who reoffend, who drink industrial quantities of alcohol in order to hit that .16 mentioned here in C-590. So they would simply decide, upon getting caught, invariably say, I refuse to blow.
And I think it's fair to say that most of the offenders, perhaps even with refusal offenses, but certainly with impaired driving and over 80 milligrams offenses, are first offenders. So they're not people that have repeatedly committed the offense of impaired driving. And I doubt very much that they would be looking at the offense and saying, for a hybrid offense, if the motion is to pass, the minimum fine is $2,000 if I'm over 160, and the fine if I refuse is a minimum of $1,000 if the Crown proceeds by way of summary conviction, which they do in most first offender cases. So for the vast majority of offenses, it would be my sense that no, the change in the motion will not lead to more people saying that they're going to refuse because it's 2,000 on summary conviction.
Because you're saying, just so I make sure that I understand your answer, it's because you're saying the majority are first offenders and as such would not be too familiar with the system. That being said, then, isn't there a danger if it is the case of the people we want to get with C-590, then isn't there a problem with the jurisprudence that the Supreme Court of Canada just set with the NER decision concerning the mandatory minimum sentence? Because isn't there a chance that maybe somebody who could have pleaded something to the court, maybe a bad, we've all been young at some point in time, and you know, although we don't, je suis pas en train de dire que c'est correct de faire.
Not saying that it's okay to commit that kind of mistake. It can cost someone very dearly, but isn't there a risk that, given the reasonable hypotheses we should foresee, there might be a very pathetic case that might end up before the courts, might mean that this whole system of minimum mandatory sentences could be seen as being unconstitutional, as being a cruel and unusual punishment, according to Section 7 or 12, I can't remember.
To provide charter legal advice to the committee. That being said, it might be fair to say, simply to point out that the change proposed in the motion is to have, instead of the current minimum fine of $1,000, a minimum fine that would be $2,000. So I'll simply point that out.
Okay.
Thank you, Mr. Chair. I'm sure the members opposite never thought they'd hear this from me, but I welcome this amendment that provides some discretion to the prosecution in these cases, and I'm particularly glad to see it come from the government because it has a much better chance of passing. But my question for you, Mr. Pruden, and I hope and expect that you saw the transcript or that you were present when Mr. Hoback testified, and it's the same question that I posed to him, and it's the practice that's grown up in at least some of the provincial and magistrates' courts where the prosecution gives notice as to whether they're going to be relying on the sections of the subsections within 255 that impose a jail sentence. So what I mean by that is a practice has grown up, whether it's via guidelines, whether it's via professional courtesy, whether it's because of there's some jurisprudence that requires them to do it. But the practice is that the prosecution will give a heads up to the court and to the accused if they intend to rely on the fact that what's before the court is a second offense or a third offense and therefore will attract a jail sentence. And in many instances, they exercise their discretion not to give such notice and have the case proceed as if it wasn't a second offense. So my question to you is the same one I asked Mr. Hoback. Are you familiar with that practice? And can you give us some sense, if so, how has it grown up? And is there anything in this bill that will have any impact on it?
The short answer is yes, I am familiar with the notice that is required of the Crown before it seeks a higher penalty based on a person's prior convictions. Okay. And that is statutory, so it's not just a practice.
Okay.
And there is a requirement in the Criminal Code in Section 727 for the Crown to give that notice. That having been said, it's very important to know that the provinces and the attorney generals of the provinces and of the federal government will typically have policy manuals that include guidelines on when the Crown should use a look-back period, which means how far do I look back before I tender that notice seeking the higher penalty. In some cases, it might be 10 years. I'll look back 10 years. If the person is clear for a certain number of years, then I won't file my notice seeking higher penalty. However, the judge is always required to fashion a fit and a proper sentence based on all the factors, whether they're mitigating or whether they're aggravating. And interestingly, in Canada, the Crown, as well as the defense, may launch an appeal against a sentence if they believe that the judge has not given a fit and proper sentence based on all the circumstances. So one can conceive of situations where the notice is not filed because of the policy, but nonetheless the prosecutor is asking for more than the minimum penalty based on all the factors surrounding the offense, the current offense.
Thank you. Thank you.
Thank you. Anything further to the amendment? And by the way, I should have mentioned the amendment is in order. I should have said that right up front. Any further questions or comments on the amendment? All those in favor of the amendment? And that carries unanimously. The clause 1, as amended. All those, any further comment on it? Seeing none, all those in favor? Opposed? None. It carries. Shall the bill carry as amended? Oh, I can do title too. And that was unanimous. Shall the title carry? Yes. And that carries. Shall the chair report the bill as amended to the House? All those in favor? And that carries. And shall the committee order a reprint of the bill as amended for the use at the House at report stage? All in favor? And that's carried. There we go. We're done now with Bill C-590. I will report that back to the House tomorrow. We do now have visitors coming to see us at 5 o'clock for those who can hang around. They are from the delegation from the Parliament of the Ukraine, and they are, you got a notice on who's coming. They're a fairly senior legal group that want to come to see us. So if you can hang around, that would be great. If you can't, fully understand. We will suspend till 5 o'clock.